paragraphs 5 and 6 of the affidavit of Mr. Kamau, that the state's evidence is that the computers of Mwananchi Group Limited were invaded. Secondly, Mwananchi Group Limited is a customer of the Ministry of Interior. And they are the ones who were invaded. So, Your Honor, how could Mwananchi Group Limited breach the contract to allow emails to proceed? Your Honor, the third point is that the essence of the matter is, if I may give an analogy, my house is burgled. And when it's burgled, instead of the police looking for the burglar, they arrest me and take me to Gigiri or Mutaiga, instead of following the burglar. So, don't I have keys to my house to need to burgle myself? How can I burgle my house? So, paragraphs 5 and 6 indicate ridiculousness of the case before the court. And now it's to go to another point. Your Honor, the IO, Mr. Kamau, with respect, admitted his limitations. He says he's not an expert in hacking, nor an expert. However, Mr. Kamau and the applicant cannot be excused from knowing the science and experience of hacking. Otherwise, they are being paid by Kenyans for nothing. Now, in today's list of authority, the second supplementary list, there is an article by the Office of Public Affairs, the US government's explaining what bagging has meant. And in this report, they say, according to it, bagging is always external, and the company whose computers are hacked, together with the employees, work together with the state to understand. It's the authority number of the authority. It's the and Your Honor.
The authority in seconds of the military list of authority.
The one dated today. Yeah. So that Your Honor, is that in this case the hacking was done by Russian agents. Here, Mr. Kamau, in paragraph 4 and 5, must be referring to the equivalent of Soviet agents. And in fact, the article shows that the intention of the Russian government was to destroy the energy facilities and other infrastructure. So, Your Honor, I urge this court to accept the view that according to science of hacking, these employees, the 6 respondents, together with their company, Mwananchi, are as patriotic as the state officers who arrested them. They are united in ensuring that this country has security. So, I want to assure my land friend, Mr. Amoy and Mr. Makujira, that we are not disagreeing on the objective. All of us want to be safe. The next point I want to come therefore is that if your honor looks at paragraph 18 of Mr. Kenya's affidavit, they are not going to investigate the external agents. The external agent, the one described in paragraph 5 and 6. Now, they are saying they are going to concentrate on the person whose house was burgled. And they want to hold for 30 days the owner of the house. How ridiculous could it be? Your Honor, the respondents admit that they are victims of want of science and the legal experience on the part of the applicant, because the applicant needs them, the respondents and their company, to combat hacking, which can damage the country. So, we therefore submit that prayer 2 is misconceived. And it is misconceived because the investigation is to be done relating to the intruder, not the person whose computers were intruded into. Therefore, prayer number 2 is irrational. Irrational in that no reasonable person would consider investigating the owner of the house as opposed to investigating the intruder, according to the search. Your Honor, it referred to a House of Law decision, page 120, which is unreasonable. I say that by irrationality, I mean...
Is it part of your bundle?
Yeah, that's correct. The part of the blue bar.
The blue bundle.
Yeah.
On what page?
At page 120, letter G. And it says, by irrationality, I mean that what can now be certainly referred to as the Venezuelan unreasonableness. It applies to a decision which is so outrageous in defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. No person with knowledge of hacking and experience would arrest these people, would doubt that the customer supplied first-class services. So, what through paragraph 18 the court's being told is that the state wants to invent the wheel as regards the law of hacking and science of hacking. And they want to find out whether the owners of a house which is invaded is doing an inside job. According to conceptually, their case is that this is an inside job. According to the science and practice of hacking, hacking is an outside job. That is how serious the matter is. Secondly, if prayer number 2 manifests an abuse of the court process on the part of the applicant, although in paragraph 18, subparagraph 11, paragraph 18, subparagraph 11, the applicant says that they don't want to punish their respondents. That is exactly what they are doing. And why? Your Honor, they are trying to go and find out whether hacking can be internally generated, something that the science has rejected, so that if you give them the benefit that there's still knowledge to be acquired, then paragraph 18 is saying they want academic research to be done. They need 30 days. I can tell them that academic research takes many years, and even if they were held for their lifetime, there would still be need for the research to continue. And that is how our treat the matter is. So, Your Honor, what is the audio object? As my last friend, Mr. Kamau Karuri said, the object of this application before Your Honor today, and why to be rejected, is that the state wants to introduce by the back door detention without trial. They now want 30 days. Next time there will be months. But therefore, this cannot be used to introduce detention without trial. If they want, let's have a constitutional amendment. Let's have a referendum like the one we had 16. Your Honor, it's significant. The Constitution promulgated on 27th of August 2010. And the anniversary of that proclamation, Article 49, which was made to secure the right to liberty, which Mr. Kamau rightly observed, is protected by Article 29, is being invaded. So the law at page 78, page 77 of the Badu says that what then is the meaning of this term? Clearly, it is a term which has great significance to the relation to the inherent jurisdiction of the court, as well as under the rules of the Supreme Court. It connotes that the process of the court must be used properly, honestly, and in good faith, and must not be abused. It means that the court will not allow its function as a court of law to be misused. It will summarily prevent its machinery from being used as a means of vexation or oppression in the process of litigation. Page 77 of the band. It's a very famous article, Your Honor, on the meaning of inherent jurisdiction of the court. And therefore, what the respondents are inviting the court to hold, if you want to hold a person for 30 days or 1 year without trial, as has happened in our history, then change Article 49 to a referendum. The courts apply the law as made by the people and parliament. The courts of law do not make law. This court being advised is being asked to make a new law of detention, which will facilitate the detention in many cases. And from the summary given by my friend, Mr. Kamau and Mr. Aduta, the decisions of this court and others have said their function is to apply the law as it is, and have released persons like respondents on basis of about 50,000 shillings to 20,000. So they are therefore making their case in the alternative. Because of the conceptual blunder or mistake, the entire application is for rejection. But then the alternative is for the respondents to be released on bail, as has been the practice. Now, Your Honor, we filed this morning some missions which are on record, and the case of the respondents is summarized in paragraph 4, but because of brevity of time, I'll just summarize what we have, the respondent are saying. Firstly, Article 49 was brought to give effect to a new man and a new woman 16 years ago. And this woman and man is one to enjoy liberty protected by Article 27. And Your Honor, we have referred to, in the big book, we have referred to a decision with authority number 4. It's a Supreme Court decision, Speaker of the National Assembly. It says that the Constitution of Kenya is a transformative document. It is a transformative document. It means that the prosecutor, the DPP, the IO, the DCI have to adopt an approach that respects the fundamental rights. Your Honor, this approach was upheld by Justice Manjanja in authority number 5, Geothermal Company, Attorney General, and I'll give the pages to the court. Saying that what my judge says in this authority I'm referring to is that KRA, which had issued a tax demand, had not followed due process. So this new man and woman of 27th August 2010 must be treated differently from the way he or she had been treated before. Prayer number 2 is putting the clock back. And I'm saying that's wrong, but if they want to do so, let's have a referendum to amend Article 49 of the Constitution. Your Honor, the issue, I try to look at fundamental rights. There's an article by a famous Justice of India, Bhagwati, and this article is number 8. Number 8 in the Bible, and I'm just going to refer to one paragraph at page 137. What to talk about? Now, it says that human rights, these rights are then regarded as superior to ordinary legislation and are used to render invalid any legislative action or administrative or other governmental decisions which are held to run counter to the enumerated rights. That's what Mr. Kamau Karuri, that's what Mr. Aduda, the other counsel are saying. You can't bring Porter to purport to amend or to overrule the Constitution. Your Honor, I'll refer my land first to Article 2, Subsection 4 of the Constitution. It says that Article 2, Subsection 4 of the Constitution. Any law, including customary law, that is inconsistent with the Constitution is void to the extent of the inconsistency, and any other act or commission is in contravention of the Constitution is invalid. Your Honor, that's the position in which this court and other courts have acted on, and I therefore have given Porter the way the interpretation given to it by Mr. Aduta and Mr. Kamau. So we can now come to the decisions interpreting Article 41, that bail or release on bail or bond is a constitutional right unless they are comparing reasons why it should not be granted. Now, the authorities I'm referring to, authority number 10 in the main list and authority number 1 in the second. But just I want to go to authority number 10. How many minutes?
Please carry on.
Okay,
I will ask you, Counsel, I'll give you 10 more minutes, so please put 10 minutes on the clock.
Okay, yeah, thank you. Thank you. It's the court, Your Honor, Your Honor, is authority number 10 at page 157. Page 156, paragraph 37, my court of appeal decision. Because, Your Honor, my friends, with respect, do not refer to court of appeal decisions on overriding, on reasons, on comparing reasons. And I'll just read paragraph 7. Lastly, we do not think that the respondent of this sufficient evidence that the release of the applicant on bail was likely to disturb public order, peace, and security. The appellants were jointly charged with the Zakaria Obando, the governor of the Migori County, since October 28, when the governor was granted bail to 8 January 2013. When this appeal came up for hearing, there was no indication whatsoever that the public order and the peace had been disturbed at all. It is obvious that the governor wields considerable political power and influence in the country compared. So, Your Honor, what my friends were telling, using different language from that one, is that the courts of law don't act on belief. They use, for Christians, the text of Thomas in the New Testament. Christ is not risen unless I touch his scars. That's what the law says. And Your Honor, as I said, there are no scars of Thomas in this application. And if we don't see the scars, then they are ready to be butted. So, Your Honor, the second authority in yesterday's release of authority is another court of appeal decision where the court was defining what compelling reasons, and it was just referring to the bench book on the test to be used when considering bail. That's legal. So, Your Honor, in conclusion, I invite the court to hold, according to the science and practice of hacking, as developed by the greatest democracy, USA. Of course, Trump will not be decided because he is under my democracy. But according to their science on hacking, it is always an inside job. It's also not so an external job. And this case was done by Russia. So I therefore commend my own friends Mr. Machira and Samoy to get Mwananchi Group Limited, the respondents, and all computer scientists to identify who this invader of the computer was. Because when Your Honor has occasion to look at the article, the US government noted that all the companies whose computers were hacked work together with the government. And therefore, in conclusion, I know the court hold. The application is wholly without merit and for dismissal. The respondent don't mind retaining if the court finds the necessary. Prayer number 3. It says that they are seeking the court to be allowed to use the computer as deceased. We have no issue with that one. So, if prayer 3 can be granted, then that too is rejected. The accused are admitted to jail. Unless Your Honor wishes me to clarify, I wish to raise my submissions there.
Thank you very much, Counsel.
State. And the reason for this, I need to start from this proposition. The Bill of Rights, as contained in the Constitution of Kenya, is not a gift from the government. It is a right that is enjoyed by each individual in Kenya. And so that is the beginning. So that the accused persons don't have to justify why they need to be free. That is the work of the prosecution. That is the work of the state. They are entitled as a matter of right to be free. The right which my clients and I believe the other accused persons are asserting is a right conferred by, among others, Article 29 of the Constitution, which confer on every person the right to freedom. And Your Honor, under Article 24 of the Constitution, where there is to be any limitation on a Bill of Rights, Article 24, Sub-Article 2, Sub-Article 3, the state or person seeking to justify a particular limitation shall demonstrate to the court that the requirements of this article have been satisfied. And Your Honor, if you look at Article 24 of the Constitution, it starts with a positive position. It says, a right or fundamental freedom in the Bill of Rights shall not be limited. Then it gives exception. So we are here today, and you are being told that the prosecution requires this court not to allow these respondents to enjoy their fundamental rights to freedom. And the question is why? Now, Your Honor, under cross-examination, the investigating officer says that as we speak now, they have not linked any of these respondents to the alleged intrusion. They say they have not linked them, those are not exonerated. But importantly, they have not linked them. And this is not the first day that this issue is being discussed on. The investigations commenced more than a week ago. You are not told, as required by Section 33 of Potter, as my learned colleague calls it, you are not told what are the investigations that have been carried out in relation to these respondents. For instance, Your Honor, one of the issues that has been raised is whether or not these people have any fixed abode. What is easier than asking somebody, where do you live? They are not saying they asked and the respondents refused to give the information. They simply didn't ask. What is easier than to ask them to disclose the gadgets they have and to release those gadgets to the investigating officer? Why has that not been asked? The compelling reasons, Your Honor, include explaining to you why these steps have not been taken. It is not sufficient to come and say multi-agency, which are the words that I see being bandied around, multi-agencies and so on. That is not a compelling reason. Whether it is the DCI, whether there are 10 agencies, it doesn't matter. the Constitution requires that you cannot limit the rights of these individuals unless they show you that the attempts they have made to obtain the information they need from this individual. One, every individual in Kenya is entitled to the right to human dignity. And under the Constitution is entitled to the freedom of movement. Why are these rights to be curtailed in relation to these respondents? Underrated, because it's important. The police have had them for the last at least 5 days. The easiest thing, I looked through the affidavits, desperately trying to find anywhere where they have explained for the 5 days what have they been doing with them. And now you're told, give us 30 days. To do what? What is it that they will not manage to do within the 5 days that they will do when you give them 30 days? Now, Your Honor, it's important for you to note that in making this application, the prosecution gave the information they thought was necessary and sufficient to enable the court to make a determination on whether or not the individuals mentioned can be detained at the police station. That is the decision they made. But look at the affidavit that they have annexed. Look at it when you retire. What is the information contained here that shows there is sensitive information? They are telling you there is, but what is the information? They have chosen not to say it because they say it's part of the investigation. That's their choice. But the accused persons are entitled to be told what is it about them. What are they accused of having done that requires them to be detained in a police station? They are entitled, it's a right. But if the prosecution decides they won't say it because it is part of investigations and it's secretive, that is their choice. But you cannot tell somebody who the prosecution says, we have not linked him yet to any offense, but we want you to detain them for 30 days, despite the fact that we have not linked them to any offense. And remember, it's a basic requirement of law. Before you even go to the motive, the actus reus itself is the one that should be dealt with first. In this case, what is the act performed by the respondents? What is the act they are accused of? Themselves. Because, Your Honor, you are told the intrusion is attributable to an entity. They've been identified the entity. But what is interesting, they have not told you what investigations have been done in relation to that entity. Who is Host Africa? Who are the directors? Who are the shareholders? Who are the owners? Where are they located? All this information has not been given to you because if it was, it would demonstrate that it has nothing to do with these respondents. And in those circumstances, the question the court must ask itself is simply this. Does the mere fact of slapping the word terrorism in a charge sheet or in an application itself constitute the seriousness envisaged under Section 33 of law? And the simple answer, Your Honor, is it doesn't. Because if you look at that section, at 3, Your Honor, it says that when this application is made, the following must be disclosed to the court: the nature of offense for which the suspect has been arrested, the general nature of the evidence on which the suspect has been arrested. No evidence has been placed before you. You have just been given copies of the details of the gadgets taken from the accused, from the respondents. The inquiries that have been made by the police in relation to the offense, and the further inquiries proposed to be made by the police. What are these inquiries that have been made? Other than the ones that they have already disclosed. And may I just point out this to you at this point. Although the IO, when he was on the stand, he said these are preliminary investigations. Look at what he says at paragraph 5, at paragraph 6, where he says that upon a background check, it was discovered that the suspicious address belonged to an entity known as Force Africa Limited. He doesn't call it a preliminary investigation. He says they have discovered. He then says, at paragraph 7 and says, that the host, Africa PT Limited, is unknown to the complainant, hence not known how they are able to intrude into the system. Again, it's not preliminary. That's their finding. But now, where it's preliminary, in paragraph 8, they say it. They say that through preliminary investigations, it has been disclosed. Meaning, where it's preliminary, the IO says it. Where it is a final finding, a discovery, they say it. They cannot come now before you and say that even these issues they have said in the affidavit where they are not called preliminary, that even those are preliminary. This is an affidavit. You cannot amend it. So, Your Honor, the bottom line here is this. There is no investigation that has been done that ties any of these respondents to whatever they are alleging is an offense. Your Honor, they have then come and talked about very serious consequences. They even talk about the Pentagon and so on. Again, the mere fact that you refer to Pentagon and other things does not make these accused persons guilty. It doesn't connect them to the crime. I could also talk about quite a number of articles I've read in the newspapers that are sensational and where people were exonerated. That doesn't help. We must deal with the people before you who are these respondents. And the question still remains, what have they done? What information have they been asked for that they have refused to give? Your Honor, you are referred to an authority. You will read it, the Honorable Justice Kamau. It was 2 Tanzanians who could flee back to their country. And remember, those were people who were charged. These are Kenyans. Majority of these people, I think most of them, by the time of practice, were not good. To say that they are flight risk without any evidence, they have not shown that they don't have a fixed support. They are getting, but they have not shown because they have not asked. They have not shown a tendency to flee. Majority of them have children. My client, the fourth respondent, has 2 children. These are family people. We are being asked to disrupt their lives, take them away from their families, because there is an investigator who says, we think in the fullness of time, one day, there might be a link. That cannot justify holding the respondents just because the IO says it. The court has a duty to balance, and when balancing, as I close, Your Honor, when balancing, the role of the court under the Constitution is to give effect to the Bill of Rights, so that the balances are not the same. We are not putting the state and the accused person, the respondents, on the same scale. The Bill of Rights favors promotion of the rights of the respondents. It is the state that is told, in the event you want to curtail them, persuade me. There is nothing that has been said today that ties these responses to any offense. And I urge you to reject this application and to admit these respondents, to grant them cash credit, to allow them to go back to their families. They have confirmed that they are willing to cooperate, as they have, with the investigating officers, and to supply any information that is sought from them in relation to this matter. Your Honor, I conclude by saying this. These respondents have, from the time they were contacted by the police, cooperated, given information, given their gadgets, gone to police stations on Wednesday, on Thursday, Friday when they go, in the same manner, suddenly they are taken. These are not people that the court should be afraid will not cooperate, because so far they have cooperated. And we urge them to allow them to go home, whatever the investigating officers want, provided them. I thank you.